Good evening, sir, and everyone joining us live. Today's session is not just another discussion on intellectual property. It's a dive deep into a space where law, branding, and the digital economy collide in real time. Our topic of discussion today is the trademark and the domain name. Mr. Yash Raj, currently at attorney at IRA Law, brings with practice that spans civil and commercial litigation before leading forums including the High Court of Delhi, Bombay, and Madras. His work sits at the cutting edge of intellectual property law, particularly in areas such as trademark, enforcement, and intermediary liability and disputes in the digital ecosystem. For many of law students in this law college or as in another NLUs, trademark and the domain names are often introduced as an static legal concepts. But through Sir work, as I followed in the recent time, we see how they evolve into high value and strategic disputes that shape markets and identities in the digital age. By the way of brief introduction, I am Krisha, a second year BA LLB honors student at NUSRL. It's a privilege moderating this session. Sir, it's a pleasure to have with you, to have you today. Before we move on to the specific, I think it's important to briefly reflect on how trademarks have evolved in today's time. Traditionally, they are seen as an identifier of goods and services within the physical markets that more people and more companies are being applied. But with the rise of domain names that in the present time and the online platforms, they have taken into entirely new dimension. Today, domain name is often the first point of interaction between a brand and its consumers. It does not just represent the identity, it controls the visibility, access, and in many ways, the market presence itself. Naturally, this has transformed the nature of dispute as well. And I think that makes the today's discussion more particularly relevant, not just from the legal standpoint, but also from the practical and strategic perspective. And I think, sir, will be better to able to tell about the trademark and the domain name disputes. Over to you, sir.
Thank you so much, Krish, for the introduction and a brief overview of the session. I'm very glad to be back at my alma mater to give a session on a topic which I currently work on, like on day to day, as well as a topic which I'm very keenly interested in. So it's a happy coincidence for me. Moving on, the topic for today will be domain name and trademarks law. As Krish introduced, that domain name has started acting in the last like a couple of decades, starting as a business identifier where people understand a business mostly through their domain names. So before we proceed to understand the legal points, there are certain technical terms which we use in like regard to the domain name system and domain name law, which I think I'll provide a brief introduction to, which will be helpful for everyone to understand like how a domain name system works and what kind of organizations are involved in managing this system and how it has evolved over time. So just to give a brief like introduction, a domain name, as mentioned by Krish, is also a unique business identifier. It's basically a human readable form of a address which is assigned to a website. So a website typically does not have a default business address in the form of a human readable alphanumeric characters. It's usually shown as IP address. So let's say for google.com won't be typically google.com. It will be somebody like some numbers in like 4264, and there's a sequence of number. It depends on like going to do a lot of technical aspect to it, but that is how difficult it is to remember domain names if they were continue to be addressed through IP addresses. So to address and to rectify the system, a concept of domain names were introduced where domain names as a human readable alphanumeric variations of those IP addresses were assigned, so that people are able to easily remember and log on to websites where they want to. So domain names could be like google.com, yahoo.com, as we all use in our everyday lives. Then there is a concept of subdomain. Subdomains are usually a part of the larger domain. They are just used to assign a particular section of a website. You can have a subdomain. Let's say this, for example, there is for the service provided by Google for the emails called Gmail has a subdomain called mail.google.com. So .mail.google.com is a subdomain of the main domain, which is google.com. Then there is an organization, like not an organization, like multiple organizations. They're called domain name registrars. A domain name registrar is the organization or a company that sells users the domain names, and they make them available for registrations so that people like you and me can actually go onto a website and buy. So the company which is providing that service to users directly is a domain name registrar. So a domain name registrar is somebody like a GoDaddy.com, which offers for sale the domains. Like, let's say if you want to buy a domain xyz.com, you log on to a domain name registrar's website and check if that particular domain is available or not, and then you can buy that domain from that particular website. Then there is a Whois directory. Whois directory is a directory which publishes information about the owners of a particular domain name. Let's say you want to know who owns a particular website. So Whois directory will allow you to see the details of the owner, the contact details, the address, the registrar contact, who is the domain name registrar, every information which of a particular domain name. You can try to see whatever is publicly available. Obviously, there are some privacy concerns and obligations which the Whois directory follows, and some information may be redacted depending on the privacy laws of the applicable state. But more or less, the information, if you want to find out who owns a particular domain name, is through a Whois directory. Then there is a domain name registry. So a domain name registry is different from a domain name registrar. And I know the two terms sounds very similar, but like they have vastly different roles when it comes to managing a domain name. So a domain name registry is an authoritative central managed database managing all domain names in a particular extension. So let's say the extension is .com. So all the .com domains are managed by one domain name registry. So for example, VeriSign is the domain name registry which manages .com domains. So all the domains which are sold through maybe different domain name registrars. So domain name registrars are for ease of efficiency, and to not confuse, we call it DNRs, is domain name registrars, and registries we'll just call registries. So domain name registrars have agreements with domain name registries to purchase domain names of a particular extension. So as I said, VeriSign manages all .com domains. All these .com domains, all the different registries, there are more than, I think, 2,000 registries, more than 2,000 DNRs who purchase these domains from VeriSign for if they want to sell a .com domain. Similarly, for India has a specific country-specific .in registry, what we call, for selling .in domains and .bharat domains. And these are managed by NIXI. NIXI is National Internet Exchange of India, which is a government of India's not-for-profit organization, which is created separately by the government. And it manages all the .in and .bharat domains for India. So there are other country-specific domain extensions. Then the extensions are generally called TLDs. They're like top-level domains. There are two types of top-level domains. There are GTLDs, which is a generic top-level domain. A generic top-level domain, as I said, could be .com, .biz, .net, which are not country-specific. They are generic and they do not specify which country they belong to. And then there are CCTLDs, which is country code top-level domains. Like as I said, .in, .bharat, then there could be .us, and then like .cn for China, .pk for Pakistan. So all these are country code top-level domains, which are managed by their respective registries in their respective countries. So I hope I'm clear with how a domain name system works. Then overarching all these system of the domain name managing a domain name system is ICANN. So ICANN is a organization which was created back in 1998, which acts as a basically a coordinator. It's not a organization which is directly overseeing the domain name registrars and domain name registries, but it just acts as a technical coordinator of the internet's infrastructure. So each of the domain name registrars and domain name registries follow certain rules and which they have agreed with ICANN to follow. So all of them have agreements between each other on how to manage and what rules to set for each other for the domain names registries. Mostly ICANN is like the overarching organization which manages it. So the agreements are mostly negotiated in favor of how ICANN wants to manage the domains. Obviously, the domain name registrars and registries also get into that pair, but ICANN is basically the organization which manages everything on the internet on a global scale of managing the domain name system. So moving on, like understanding the basics of the domain name system and introducing the terminologies, we'll move on to how it intersects with trademark law. And coming to the aspect of trademark law, we'll go into how a domain name is read and equated, like because there is no system which in India, there's no law, there's no sui generis legislation which governs how a domain name system will operate or how a domain name system will be, how a domain name will be protected. So how the courts have read domain names into the statutes we already have it with us. So the definition of a mark in the Trademark Act under Section 21M reads that a mark includes a device, brand, heading, label, ticket, and then there is a word called name. So courts have interpreted to mean that the word inclusion of the word name in the definition of a mark includes a domain name, and that is how domain names are treated akin to a trademark in a lot of contexts to accord it protection similar to a trademark. And we'll discuss in with case laws how the these with precedents how like the system has evolved and like how the courts have evolved with this system of understanding how a domain names now acts as a business identifier and then provide like should be provided equal protection in case of any infringement or passing off. So I'll just give a brief overview of Section 29, which deals with infringement of a registered trademark, which protects against any unauthorized use of identical or deceptively similar or confusing similar mark that are likely to cause confusion. And then there is Section 27(2) of the Trademarks Act, which deals with passing off. Passing off, I'm sure just because people are attending this IP session, you will be aware that passing off is a common law remedy which protects even unregistered trademarks. So a domain name is then under the Trademark Act has been evolved to provide both protections of a passing off and an infringement. The standards obviously apply to what a general infringement and passing off regime provides to a normal trademark. Domain name is also provided a similar protection therein. Now moving on to one of the initial and landmark decisions on recognizing and protecting domain names as business identifiers. So this is the case of Yahoo Inc. versus Ashok Arora, which is from 1999 when the system of domain names was not very familiar and it was very recently introduced, like how AI has been evolving recently. Domain names and internet was evolving back in the late 1990s in India. And then at that point of time, Yahoo Inc. owned the generic, as I mentioned, generic top-level domain called yahoo.com, which was accessible throughout the world without any territorial limitation. The defendant in this case, Akash Arora, registered and launched a similar service under the domain yahooindia.com and started using to provide similar internet-based services because Yahoo used to provide those internet services, and Akash Arora also launched a similar service in India. This case then led to the popular and most important judgment of the Delhi High Court, which recognized that the domain name serves as a business identifier and as a source identifier, and since it performs as a source identifier, it acts like a trademark, and it is the court held that domain names are entitled to legal protection under the principle of even passing off So this is one of the earliest cases where it was recognized that domain names need protection similar to a trademark, and that is how the system has evolved. And then moving on in 2004, there is another landmark judgment which reaffirmed the principles recognized in Yahoo versus Ashok Arora and gave it a protection and recognized the principles of how domain names ought to be protected under the Trademarks Act. So in 2000, this is a 2004 Supreme Court judgment in which the appellant, Satyam Infotech, alleged that SIFInet Solutions had deliberately registered and ran a domain name that was confusingly similar with their own domain names. So the appellant herein had registered domain names in 1995. And the principle in trademark law, as you guys would know, is whoever is the prior user or the prior adopter of a particular trademark takes precedence over a subsequent user. That is how you determine who is the prior right holder in a particular trademark. Similarly, here the appellant had registered his domain name. Their domain name in SIFI.net, SIFI Small, SIFI Real Estate.com, like various marks featuring SIFI back in 1995. The respondent herein also started a similar business of internet marketing in 2001, 6 years subsequent to the appellant, and started using the domain name SIFInet and SIFInet and SIFInet.com, SIFInet.net and SIFInet.com. And the Supreme Court in this case recognized the need for a protection, comprehensive protection for domain names, and held that although the same rules which apply to a trademark will be provided to a domain name, although there is no specific law in India which has specific provisions and governs domain names, but the Supreme Court made it applicable that a Trademark Act would provide protection to a domain name. Prior to this, now I want to go back to the system of understanding how globally the domain name system has evolved, and for that we need to understand the Uniform Domain Name Dispute Resolution. So what we call it UDRP. So UDRP, so as I mentioned earlier, ICANN is the overarching body which governs the domain name system of the entire world. UDRP was a system created in collaboration between WIPO and ICANN. WIPO is the World Intellectual Property Organization, and ICANN, where they adopted practices and got on board all the domain name registrars to agree to it in their agreements between them to resolve domain name disputes through a quick and a very efficient mechanism of a short arbitration proceeding where anybody who has a genuine interest and wants to file a complaint against a particular domain name which they believe is involved in, let's say, cyber squatting, they can file those complaints before through UDRP, and it's then sent to, let's say, the WIPO mediation center, and then a mediation and conciliation center is and then an arbitral panel is involved, and the whole arbitration proceeding is concerned. But the essential aspect of this is it's a very short procedure and the timelines are strict, so it's less cumbersome than going to a court to resolve domain name disputes. And this system was essentially required because domain names are not territorial, they are extraterritorial. So any domain, let's say I register a domain xyz.com in India, nobody in the entire world can then register that particular domain. In contrast, a trademark is a territorial registration. If I register a trademark in India, anybody else can have a registration for that mark in any other jurisdiction. So domain name in that context is different, and that is why there was a need for a universal framework of resolving the disputes related to domain names. So how the UDRP evolved was, as I mentioned, was a consultation process between WIPO and ICANN, and then a system of UDRP was involved where there are rules governing how a UDRP proceeding follows. So there are three essential ingredients which a complainant must prove to satisfy and succeed in a complaint in a UDRP proceeding. The first is he has to prove that the domain name is identical or confusingly similar to their protected trademark. The second is the registrant has no rights or legitimate interest in the domain. Basically, whoever you file a complaint against, let's say there is a trademark called GOGGL, which is like a misspelling of Google, and Google LLC wants to file a complaint before through UDRP for either a cancellation or a transfer of that domain, then it will approach WIPO's arbitration center, file a UDRP complaint, and then it has to prove that the registrar of GOGGLE does not have legitimate right or interest in that domain, and that the registrant is registered and being used in bad faith. So bad faith is a very important consideration here to resolve a domain name dispute, because mere similarity between a particular domain name and like so to give you like to come back a point, UDRP says all 3 points have to be satisfied. Like not just one component, all 3 points which is listed is identical and confusingly similar to a protected trademark. The registrant having no legitimate rights or interest in that particular domain, and the domain name being registered and used in bad faith. All of the three elements have to be there for a UDRP complaint to succeed. Even absence of one of these factors can lead to rejection or dismissal of your complaint in UDRP. So this is a thing which has to be borne in mind, and we'll be like I'll be adding more on this in the context of like how it has evolved in India. So all these three components has to be in mind, and UDRP has specific guidelines on what is considered evidence and use of registration and use of a bad faith registration of a domain name. So those three aspects which involves evidence of bad faith registration. First is a profiteering intent, which is basically let's say like somebody registers a domain name with harmful intentions, basically to, let's say I want to purchase a domain name just for the purpose of selling it at a high price when I don't hold legitimate interest in that domain, and I just want to make a profit out of by selling that particular domain. Let's say I don't own the mark, Samsung.com, but I have registered Samsung1.com in the hope that maybe Samsung will buy it from me one day, and I advertise on my website, which is hosted on that domain, that I'm willing to sell that domain for $500. That is a profiteering intent, which is an evidence of bad faith registration. Then there is a business disruption. Basically, you register and block a domain name so that the trademark owner who has a legitimate interest in that particular mark is not able to register that mark. So that is why if you go back to the second point, which says you should also have a legitimate interest in a particular domain when you are registering that domain, and if you don't have a legitimate interest in that domain, then that is a ground for a bad faith registration. Then there is third, which is creating confusion, which is basically let's say I'm using to ride on the goodwill of another, or basically to ride on internet traffic and get malicious clicks by using a trademark which is owned by somebody else. Like example of Samsung, I use Samsung.com to sell maybe my own phones just to get internet traffic, because when people search Samsung.com, my domain also appears, and then people believe that my domain is also related to Samsung. They click on my domain and they come onto my website and look at my website to like get confused. So that is also an evidence of a bad faith registration. So all these three things are examples of bad faith registration. I remember like a very recent example of how geohotstar.com was registered by somebody, and it was mentioned on the website itself that they intend to sell that domain. That is exhibit A of what a bad faith registration would be, because after the announcement that Geo's platform will be merging with Hotstar's platform, that was an opportune movement for somebody to register a domain GeoHotstar, which was done by an individual, and then that individual started offering for sale GeoHotstar at a very exorbitant price, saying that I will sell it, I will not give it up, I want to make money out of it. So the moment GeoHotstar files a complaint against that particular domain, it is, and they show that particular website which says that I want to sell the domain at a price and I want to make money out of it. That is evidence of bad faith registration. In India, there is a similar INDRP policy where uh, the disputes involving .in and .bharat domains are resolved through the INDRP policy. INDRP is .in domain dispute resolution policy, and which is governed and managed, administered by the National Internet Exchange of India, NIXI, which is basically the organization which manages the .in registry. So the .in registry, as I mentioned, manages .in and .bharat domains, and .in .bharat domains. For any dispute relating to .in .bharat domains, you have to go to NIXI and not you initiate a UDRP proceeding. UDRP is only for GTLD domains, which is .com, .biz, .net. Now, moving on, there is a very interesting history of how the UDRP and INDRP provisions have evolved, and mostly the INDRP provision has evolved due to a very specific and interesting issue which came up back in 2012. So, to give a brief background, there's a case called Stephen Koenig versus arbitrator of NIXI, which is before the Delhi High Court. So before this case was filed, there was a complaint filed under INDRP before NIXI, where a complaint was filed that somebody named Jagdish Purohit alleged that a domain name internet.in was registered by Stephen Koenig and was identical to his trademark. His trademark was internet. In respect of, he had a registration for internet in respect of tobacco and related products in class 34. So he alleged that registration of the domain internet.in by somebody who's based out of US was bad faith. He had no legitimate interest in that registration, and he sought a transfer of that particular domain to himself, saying that he is the proprietor of the trademark in India, and that because it's a .in domain, he should be transferred that particular domain because he is the legitimate right holder of that particular trademark. In that proceeding, the arbitrator who was handling the complaint concluded that the domain internet.in should be struck off because, first of all, internet is a generic word, nobody should have like monopoly over it, and it should be confiscated and kept by the .in registry, which is like something like a kind of a different decision which usually comes because the nature of the mark involved. So in the Stephen Koenig case, the arbitrator concluded that nobody will have the domain, and he rejected the complaint of the rejected the prayer of the complainant, Jagdish Purohit, that the domain will not be transferred because nobody can have rights, but he did not also allow the registration by Stephen Koenig. Challenging this arbitration decision, the complainant herein moved to the Delhi High Court and filed a case before the Delhi High Court, alleging that he is the legitimate right holder of the mark internet. He has a registration for internet in class 34 for tobacco products, and he should be allowed to have the domain name registered. So just a brief background, a very short background of how an INDRP was introduced. So .in domains came in a bit late, and a lot of individual registrants in India and a lot of global business leaders had already started launching their own websites, but there was no country code specific TLD in India at that point of time. So when NIXI was set up, the objective was to allow and give preference to Indian registered trademark holders to apply for a registration of .in domains. So let's say you have registration for a mark XYZ, then you will be given preference to register the .in domain, which is xyz.in. It was called a sunrise period. That period was anybody who had a registration prior to 2004. This policy was launched in 2005. So when the .in domains were like started to accept registrations. In this case, the complainant Jagdish Purohit did not use that sunrise period to register. Somebody based out of US registered .in domain. And then he filed a complaint, and then his complaint was dismissed. and he was not, his fare was not allowed basically. And then he came to the Delhi High Court, where he alleged that although he's missed the sunrise period deadline, which was allowed by the Delhi High Court, which was allowed by NIXI, but he's approaching the Delhi High Court because he is a legitimate right holder. He should be given allowed to register the domain name internet.in because he is the registered proprietor of that trademark. The Delhi High Court went to the provisions, the arguments were advanced that CUD INDRB is like objectively and officially based on UDRP. It's like a mirror of how the law has evolved in UDRP. The requirements in UDRP to file a complaint, to succeed in a complaint, has all been replicated in INDRP. However, there was a difference therein, where in INDRP there was a specific line which says that in administrative proceedings, the complainant must prove each of these three elements. However, in INDRP, there was an omission that this line was not present. So there was a confusion whether all three grounds, all three elements need to be proved to succeed in a domain name complaint. And this was one of the issues which was being contested by the complainant, where the complainant said, see, INDRP does not emphasize that all three elements must be used on two phases. First of all, there is no express statement similar to UDRP. And the second point, that after each point in the UDRP provision, there is an and involved. So in UDRP, para 4A of the policy says, your domain is identical or confusingly similar to a trademark or service mark in which the complainant has rights, and second point and third point. In INDRP, the difference was there was and only between the second and the third point. So there was a dispute whether either you just prove point 1 or you prove point 2 and 3. Point 1 being you just prove confusing similarity between a mark. You don't need to prove legitimate interest and bad faith for that purpose. So this was a huge debate, because without showing bad faith, I'll come to that point later, where bad faith is more like very important to succeed in a UDRP complaint. Why bad faith should be there in place to protect legitimate registrants, because just because a mark is confusingly similar to another mark cannot be a ground to allow somebody to succeed in a domain name complaint. I'll back my points in some time. I'll just explain the background of Stephen Koenig case. So in Stephen Koenig, the Delhi High Court single judge firstly held that, see, there is no and between the second and the third point. There is just there's an and only between the second and third point. There's no and between the first point and the second point. So we'll treat first point itself would allow. So even if a domain name is just confusingly similar to another, that is sufficient to succeed in an INDRP proceeding. And the Delhi High Court differentiated that UDRP is different, INDRP is different. Then an appeal was filed against this decision by the learned single judge, and that appeal succeeded. I'll just read out the relevant portion of that particular judgment, which held that para 4 of INDRP is different from para 4A of UDRP in a significant way, while each of subparas 1 to 3 of para 4 of UDRP are required to be proved by the complaint. As far as para 4 of INDRP is concerned, a complainant can file a complaint on the premises outlined in para 1 to 3 of para 4. There is no requirement that each of these three elements are shown to exist. If this is understood in light of the fact that the conjoint and is missing, and at the end of para 1 of UDRP, then it is possible to interpret para 4 of INDRP to mean that a complainant can succeed if he proves that the ground in subpara 1 exists by itself. So basically, the court held that if a domain name is confusingly similar to a mark in which you have rights, in INDRP you will succeed. And this led to a very problematic interpretation, because INDRP was a mirror of UDRP, and lack of that particular and being reproduced in the INDRP provisions led to a lot of confusion. And subsequent to the Delhi High Court enforcing this, a lot of complaints started getting filed where the marks were just confusingly similar to a particular mark, and complaints started getting entertained before NIXI. To address this, the INDRP rules were later modified, and was added after the first point, so that it now exactly mirrors what the requirements in UDRP are. So now, at this point of time, the INDRP rules have also been modified, and now all these three elements of confusingly of a mark of the domain name be confusingly similar to the mark, the registrant having no legitimate interest, and the registered and the registration and use of the domain name is should be in bad faith. All of these has to be there for a domain name complete both in INDRP and UDRP to succeed. Now, coming on to the more recent developments which have taken place. So, very recently in December 2025, there was a series of judgments passed by the Delhi High Court single judge, where certain guidelines have been introduced regarding the, to curb the practice and misuse of domain names, where the Delhi High Court noted that there is a severe instances of fraud being reported, where a lot of innocent consumers are being duped because people are registering similar domains to what domains are already registered, with which there are legitimate right holders who hold legitimate rights in that mark. So there are like cyber squatters, there are typo squatters. Cyber squatters are basically who sit on the domain. Let's say, as I mentioned, the Geo Hotstar case, which is a classic case of cyber squatting. Then there are typo squatting. Typo squatting is, as I mentioned earlier, registering google.com instead of google.com, and then trying to attract internet traffic on google.com. Then there is identity theft and impersonation, where a lot of famous personalities, actresses, actors, movie stars, and other famous personalities, their name was used as a domain name. Let's say Jackie Chan, or let's say Salman Khan. These domains were being registered by random people, and then it was used to attract internet traffic and maybe provide some like sell some products which appear not which to be appear to be associated with that particular internet personality. So that is called identity theft in the case of domain names. And then there is reverse domain name hijacking, which is basically where a bad faith registration is done by somebody to block a particular domain, as I mentioned earlier. So all these practices were taken note of by the Delhi High Court, and a series of matters were listed together and heard for like a period of 2 years by the Delhi High Court. And finally, the judgment was passed in December 2024, where a series of guidelines have been issued, where domain name registrars, as I earlier mentioned, domain name registrars are the entities which sell domain names to everyday users. They were directed to implement certain directions which will help curb the practice of this misuse and infringement of domain names. So what were the directions? I'll just in the context of trademarks, there were a few directions which involved like privacy protects and like grievance officers. But in respect of trademarks, the main ones were that injunction sought by a well-known brand shall be granted for infringing domain names, as well as any other similar variations of the infringing domain name, and the domain name registrar shall ensure that no alternative domain name is promoted or suggested to a prospective registrant. So basically, I'll just give a little background in this context. When you go to register a domain name, you go to a website of a domain name registrar, let's say GoDaddy.com or BigRock.com or Open Provider. You log on to that website, you search for what domain name is available. Let's say I want to buy, for example, Samsung.com. I'll go to the domain name registrar's website, I'll type Samsung, I'll see what domains are available. There is no currently, before this judgment, there is no prohibition on anybody registering any domain name. Anybody can register a domain name. Obviously, let's say I want to register Samsung.com, I can go and register Samsung.com. There's no express prohibition on that. However, obviously, there is a situation where Samsung can file a complaint against me before UDRP or INDRP, depending on what domain I buy, to say if I am using that particular domain in bad faith and I have no legitimate interest. Let's say I review Samsung's products and I have samsungreviews.com. That particular domain where I have generally providing information regarding Samsung reviews, Samsung's products, would be considered not a bad faith registration, because I'm not misusing, I'm not profiteering, I'm not selling that domain, I'm not misrepresenting or confusing customers. I'm expressly saying that this website is for reviewing Samsung's products. So samsungreviews.com in that case is a genuine registration of a domain. However, the Delhi High Court in its guideline has said that any alternative domain name cannot be provided. So once, let's say, a domain has been injuncted, let's say somebody registered samsungreviews.com earlier and was using it as a bad faith registration to lure customers to sell its own products on that website, or maybe was using it in bad faith and misrepresenting customer that it was Samsung itself which was providing those services on through that particular domain. Then, because of that particular user, because the domain samsungreviews.com is banned, no similar domain can be registered, which is basically samsungreviewers.com, Samsung maybe some misspelled review or something, review.com, review.net, review.biz. Any similar domain cannot be registered because samsungreviews.com was held to be infringing and was banned completely from being prohibited from registration. Then domain name registrants were also asked to not promote, market, or extend optimization services to any infringing domain names. Then there was an introduction of a dynamic plus injunction in this case. A dynamic plus injunction was, to understand the case of what a dynamic or dynamic plus injunction is, a dynamic plus injunction is where the courts need not adjudicate every new infringement which is found by them. What they do is they delegate this adjudicatory function to either a joint registrar. So basically in courts there are system of joint registrars who are also judges in that favor, but their role are limited. They are not proper courts. They do case management hearings. So the court, what it did in this case was delegate that function of determining of whether or not there was infringement by a particular domain for further domains. Rather than filing new suits, you can implead new domains which you find in existing suits. And that is the concept of dynamic plus injunction. Dynamic injunction, which the court in this case includes a dynamic plus injunction, which means that automatically when a particular injunction is passed against a particular domain name, future domain names, what three criteria, if they are following any of the three criteria laid down by the court, will be also be injuncted in that regard. So the three criteria are either the trademark appears as it is in the domain name, either the trademark appears with a prefix or a suffix, or the trademark appears as an alphanumeric variation of a particular domain name. So basically, let's say I have a domain, let's take Samsung same example. I have a domain Samsung reviews. So if Samsung gets an injunction, in the nature of what the Delhi High Court in Dabur India or Ashok Kumar has said, a dynamic plus injunction, then Samsung reviews would definitely not be registrable even after adding a prefix or suffix like review, Samsung, Samsung review, Samsung review, Samsung review, or anything will not be registrable because Samsung reviewer or Samsung reviews has been injuncted. Then even if you use like alphanumeric variations could be I use zeros instead of O's. I use 1 instead of L to try to avoid. So alphanumeric versions, the concept of alphanumeric variations came to be evolved because of the fact that a lot of miscreants and misuse was happening because people were registering domains which obviously did not contain the exact domain. Like let's say I'm using google.com where I use instead of the Google O's, I used zeros. So it's G00GLE. Just to so it looks similar, to cause confusion, but it still gets you the internet traffic you want because it looks similar. So in this case, the courts even injuncted alphanumeric variations of these domain names. And this judgment is currently, although under challenge before the division bench of the Delhi High Court, Uh, but these slew of directions have changed and evolved how the practice of misuse and registration of domain names which are not legitimate right holders have led to an instance where there are dynamic plus injunctions being granted, from an instance where we started in Yahoo versus Ashok Arora, where people had to explain even for one domain why that particular domain name was found to be infringing, where we have come to a stage where in Dow versus Ashok Kumar there are dynamic plus injunctions being granted, where even if a domain just appears, the injunction automatically operates. So this is how the courts have evolved over time. But coming to another aspect of why I want to discuss bad faith registration, and my example of why just blanketly injuncting domains just because of them being just containing a particular mark would be difficult and like problematic for like legitimate right holders and legitimate users. So as example I gave of samsungreviews.com. Samsung reviews, as I said, may hold legitimate reviews of Samsung's product. That is considered fair use under the Trademarks Act, and that use is allowed under Section 30. Similarly, let's say I hold a trademark, because trademarks are territorial in nature. Let's say I get an injunction from a court in India for a trademark, let's say Amul. If I get a trademark injunction on Amul in India, let's say there is somebody else outside India, where in a jurisdiction where there is no presence of Amul ever, and there is somebody who wants to legitimately use its rights, and there is no penetration, there is no concept of trans-border reputation which has been recognized in that jurisdiction, he should also have the right to register that particular domain because he's a bona fide registrant of that particular domain. But the issue with domain names is because of its extraterritorial nature, there is no curb in how to stop miscreants from using and registering domains. Because unlike a trademark where the registrations are specific to a particular jurisdiction, once a domain name is registered or cancelled for one particular domain, it's cancelled everywhere. So you cannot, if let's say a domain, as I say, samsungreviews.com is cancelled in India, it's not accessible anywhere. The domain stands cancelled, it cannot be registered till the time like the cancellation is in force. So that is the issue, and that is a tussle which the courts are also trying to find a balance between. UDRP and INDRP obviously are like one of the most evolved mechanisms to deal with the extraterritorial nature, where you have to prove that not only the mark has to be in confusingly similar to your trademark, but it also has to be in bad faith, and the other side, the other party should not have any legitimate rights. The courts are also trying to evolve this, but there's still a continuous tussle, and we'll see how the field of domain names and trademarks evolve in future. Thank you very much. Any questions?
Thank you, sir, for the valuable insights. Like we would now happy to take few questions from the audience in the YouTube or from here in the StreamYard. Any questions from anyone? Sir, we have a question from the YouTube that it says that in your experience dealing with domain name disputes, how do courts reconcile the traditional like territoriality, the inherently boundaries of the internet?
As I explained earlier, there is a continuous tussle still going on. Courts are trying to recognize that the domain names are extraterritorial in nature, so there has to be a very serious case of misuse of a particular brand. However, Indian courts have started to recognize this fact more seriously, and there is a stricter enforcement mechanism in place in India where the courts pass directions to the domain name registrars to lock and suspend the domain. Locking and suspension of a domain means that the domain, the website hosted on a domain is no longer accessible, and then the court will ask the whoever the complainant, the registrant is, to approach the court, and then the domain name dispute is adjudicated. If in a the issue is, if the website is accessible in a particular country, let's say India, it gives the courts in India jurisdiction to adjudicate that case. So even if, let's say, I have legitimate rights in a trademark outside India, there is a possibility that my website and the domain might be blocked in India, or there are directions issued to there are direct Department of Telecommunication and the Ministry of Electronic and Information Technology to block the website or the domain in India. Lost supply. As I was saying, there are directions issued to the department by the Department of Telecommunication to block a particular website in a particular domain, but
Sir, you are not audible. Sir, we'll join in few minutes. We will wait for sir to complete the answers, and if any other person have any question, we would take after sir join the meeting.
sorry, there was some internet issue on my end.
No issues.
Any more questions?
Sir, I guess the answer you were giving it was left in the middle. Could you repeat the last answer? If
What I was saying is, the courts have started issuing directions to do a geo blocking basically of a website if it's accessible in a particular location. However, even in case of a legitimate right holder who has a legitimate right in a particular jurisdiction, court will adjudicate that dispute independently and try to issue directions where a particular website is maybe geo-blocked in this particular territory and not accessible throughout the globe. The geo-blocking directions are passed to the Department of Telecommunication, where uh, that particular website may not be accessible in, let's say, India, but however, where the legitimate right holder is be able to access it, may access it. However, this is not the usual case. I'll just give an example there of so Tata. Tata is a very popular and well-known brand in India. There is an Italian brand which sells Tata under the mark Tata in Italy, and it's an old Italian brand which sells leather products. Being a legitimate right holder in their own right in their own country, and being the prior adopter in that particular country, both these parties are coexisting in the market. Even in India, you can, if you search and go to Tata Italia's website, you can still open Tata Italia's website and access it. So the courts have to find a balance where there are legitimate right holders. When both parties are legitimate right holders, there's no cause of confusion arising, there's no bad faith involved. Then obviously both parties will need to have like independent rights, similar to how we have into trademarks, where, let's say, uh, two registrants have registered similar domain names. Section 28 recognizes that if similar domains are registered by both parties and they have like independent rights, nobody can sue each other. They can may sue third parties, but they cannot sue each other in that context.
Sir, we have one more question that in conflicts between the rules of UDRP and the INDRP, the rules of former one will prevail or not?
See, INDRP and UDRP are both independent like policies which govern different aspects of a domain name dispute. UDRP only governs GTLD domain name disputes, which is .com, .biz, .net kind of disputes. INDRP only governs .in and .bharat domain name disputes. So both are usually exclusive. They operate in different spheres. INDRP domain like .in and .bharat domain name disputes cannot be filed through a complaint before WIPO, which only deals with UDRP disputes. So they're most usually exclusive. There's no point of consideration of them being in conflict with each other.
Are there any further questions? Sir, I have personally one question. Uh, I was asking that the first of all that the session was very engaging and the insightful discussion. Especially your perspective how the dispute has been arising at the present time, and you himself, your yourself has represented in many matters like in the Vistara and in the case of the Max hospitals. Sir, my question is that given your experience representing the domain name registrars, how do you see their role is evolving in the present trademark disputes? Like, are they merely intermediaries or are courts increasingly expecting a more proactive compliance role in the present time?
So domain name registrars are effectively intermediaries in their role because similar to what it's like any service provider. They are merely providing services. Service is selling domain names and letting you manage the domain names. The court have repeatedly have like consistently held that domain name in their service of providing domain name registrations to users are intermediaries. That has been held by courts. However, in like recent some of the judgments is like similar to Dabur, where it has been held that in case a domain name registrar fails to comply with the directions which are being passed, it may not be considered an intermediary, or it is providing value added services where it is allowing miscreants to like promote their services, promote register like infringing domain names much more frequently. The courts have also found them like they may not be treated as an intermediary. In that case, there have been directions passed against domain name registrars where they've been locked completely from operating in India. So there have been directions passed against even the domain name registrars in that case. However, in general, for the purpose of providing the domain name registration services, domain name registrars are intermediaries.
Thank you, sir. Mm, if anybody has, if anybody doesn't have any further question, we could end the session. Sir, thank you for such an interesting and insightful session. Personally, I feel I have gained a lot from your practical experience on these issues, and I am sure that same holds for all the people in the YouTube and the other person who have joined the session here. And thank you for your time and thank you for joining us. And all of you, great evening. Have a great evening, sir.
Thank you so much.